Hello friends, this is CA Shivashish Karnani and today I am going to discuss a very important concept which is prevalent across all the tax laws. Now let us say I considered a particular income to be taxable under Income Tax Act and I paid the tax thereon on that income. Later on the government clarifies or the court gives a judgment that the particular income was never taxable under Income Tax Act. However, I have already paid the tax on that particular income. Similarly, under GST law, I considered a particular transaction to be taxable under GST law. Later on, the government clarifies that the transaction was never taxable under GST law, or the court gives the judgment that the transaction was never taxable under GST law. In that case, since I have already paid the tax, whether I can claim the refund of that tax amount, whether I am eligible to claim the refund of that tax amount along with interest. I am going to discuss this concept taking into facts of a particular transaction. Now let us say what happens is that when an employee doesn't serve his or her complete notice period, in that case the employer recovers part of the amount from that employee. So let us say the employee was required to serve 2 months notice period and the employee only serve 1 month notice period. In that case, what employer generally does is that the employer recovers 1 month salary from that employee because he or she haven't served the entire notice period of 2 months. And because there were a lot of confusions under GST law initially, what happened was that on that 1 month amount which I as an employer recovered from the employee, I have paid the tax on that particular amount by considering that amount to be agreeing to tolerate an act, and for that reason I computed 18% GST on that amount and paid the tax to the government. Recently, government by way of a circular in August 2022 clarified that notice pay recovery in our case, which was 1 month, notice pay recovery is not liable to GST. There was never a toleration which was done by the employer on this account. There was never a consideration which was there in this particular transaction, and accordingly this transaction was never liable to GST. It was never liable to GST. However, since as I already mentioned that initially there were a lot of confusions, and in year 2017 when GST was introduced, I paid the tax thereon on that particular notice pay recovery. Now the tax was paid in 2017. The circular is coming out in 2022. Whether after 5 or 6 years I can claim the refund amount of that particular tax which I have paid on this transaction, and if yes, how I am going to file the refund amount. I am going to discuss all this in the coming part of the video, and I am going to show that recently Kerala High Court has given a judgment that the refund amount can be claimed, and there are various other judgments which says that when the circular has been issued, the timeline has to be computed for the purpose of claiming refund from the date of issuance of that circular. Now GST law provides that 2 years timeline is to be followed for the purpose of claiming refund. The timeline is going to be calculated from August 2022 when the circular was issued, and I still have time to claim the refund even for the tax which I paid in 2017, even for the tax which I paid in 2018. I can claim the refund. Also, I am going to show that how on GSTN portal I am going to claim that refund amount. So let's start. Now friends, I am on circular number 178. This has been issued recently by the Government of India, and this has been issued on 3rd August 2022. This has been issued very recently. It says, the subject says GST applicability on liquidated damages compensation penalty arising out of breach of contract or other provisions of law. When we go through this circular, I'm just going to run on the relevant part for our discussion regarding notice pay recovery. Here are we. So it says forfeiture of salary or payment of bond amount in the event of employee leaving the employment before the minimum agreed period. Employee leaving the employment before the minimum agreed period. It says an employer carries out an elaborate selection process and incurs expenditure in recruiting an employee, invests in his training, and makes him part of the organization privy to its processes and business secrets in expectation that the recruited employee would work for the organization for a certain minimum period. So he is going to work for a certain minimum period. Premature leaving of the employee results in disruption of the work and undesirable situation. The provisions for forfeiture of salary or recovery of bond amount, for forfeiture of salary or recovery of bond amount in the event employee leaving the employment before the minimum agreed period, are incorporated in the employment contract to discourage non-serious candidates from taking up employment. The said amounts are recovered by the employee not as a consideration for tolerating the act of such premature quitting of employment. This is what I said, that there is no consideration, that there is no toleration by the employer regarding that the employee can leave the employment without serving the notice period or without serving the complete bond period. Therefore, I'm just coming to the last part of this paragraph. Therefore, such amounts recovered by the employer are not taxable as consideration for the service of agreeing to tolerate an act or situation. Therefore, such amounts recovered by the employer are not taxable as consideration for service of agreeing to tolerate an act or situation. In our case, the employer recovered 1 month's salary and the same is not a consideration, and accordingly, there is no GST applicable. Now, let me go through the gist of the judgment which has been recently passed by Kerala High Court on this particular aspect. This is the judgment, this is the crux of the judgment of the Kerala High Court, and the judgment was rendered in the case of Mannapuram Finance Limited. Herein, what happens was that the petitioner who has filed this case in the Honorable Kerala High Court has paid the amount of GST on the notice pay recovery which it has done from its employees. After coming of this circular, the company files refund application on the GSTN portal. The refund is rejected and the company file appeal. The appeal is also rejected. The appeal is also rejected by the appellate authority. Now, while filing the second appeal, as we know that the second appeal has to be filed with GST tribunal. Since there is no GST tribunal which has been established till now, the company filed the case before High Court. And the High Court states the following. The decision of High Court. Refund allowed of the GST paid on notice pay recovery. Appellate authority and original authorities were wrong in rejecting the refund amount earlier. The refund was granted by the Honorable Kerala High Court. What are the ratios which are given by Kerala High Court? It says circular number 178, which we just saw, is clarificatory. It is only clarificatory and has a retrospective effect. It is very relevant to note that a circular has retrospective effect because it clarifies the existing law. It clarifies the present law, and basis that clarification, the refund was being claimed by the party. Circular merely explain the current law. Case can be filed directly before the High Court even without establishment of GST tribunal. The court specifically says that just because GST tribunal is not established, the party cannot suffer because of that. The petitioner cannot suffer because of that, and we are going to entertain this petition. And the court accordingly grants refund along with interest. It also orders for the payment of interest. It further says there is no requirement of GST payment under protest. There was never any requirement to pay GST under protest in this particular case because the employer was earlier considering the transaction to be taxable, however, which has been later clarified to be non-taxable under GST law. Now, again, a very important concept which is going to come up, in important point which is going to come up by department when you file this refund. They are going to say that you have already recovered the amount GST amount from the employee. In that case, we have to explain to the department that we haven't recovered the amount of GST from the employee. Our agreement says that we can recover 1 month salary from the employee, the example which we discussed, and 1 month's salary which we have recovered from the employee doesn't include the GST amount. There is no mentioning of the GST amount. It is a lump sum amount which we are recovering from our employee because he haven't served the complete notice period. The next point is, which I was discussing, was whether we can claim the refund for a transaction, a tax which was paid in year 2017, 2018, 2019. Yes, because the judgment of Honorable Gujarat High Court in the case of Joshi Technologies International case, it says that when there is a mistake of law, when there is a mistake of law as in I considered a particular transaction to be taxable, and the government later on clarified that the transaction is not taxable under GST law by way of a circular, it is a mistake of law, and accordingly the limitation period is going to start from the date of issuance of circular. It is going to start from the date of issuance of circular. Now, the since the circular has been issued in August 2022, the timeline is going to start, the 2 years timeline is going to start from August 2022, and I have time till July 2024, July 2024 to file the refund claims for all the past periods, for all the past periods. Now, coming to the last part of our discussion, how we are going to file the refund claim. How we are going to file the refund claim. So I have logged in to the GST portal. You are going to log into your GST login account on this website, gst.gov.in. Here you are going to go under the tab refunds, and you are going to click application for refund. Application for refund. You are going to see there are various types which are available on the portal. However, we are not concerned with any one of this. We are not concerned with any of this specific reason. Our case is going to fall in excess payment of tax. It is going to fall in excess payment of tax. We have paid excess amount of tax which was never payable, and accordingly, I am going to file the refund application by selecting the respective financial year month, and we are going to proceed for creation of this refund application. With this, I hope you understood the concept which I wanted to discuss, and I'm just closing this video. I'm going to see you soon. Thank you.